Hello, everyone, and welcome to this webinar organized by LiveLaw. Through this conversation, we will discuss how patriarchal notions manifest themselves in cases that concern sexual assault and rape specifically. And we'll also touch upon what that means for women's constitutional rights. I'm speaking this evening to Navroz Sirvai, who is a senior advocate at the Bombay High Court and is one of the leading practitioners of constitutional law. This conversation will last approximately an hour, and then we'll go to a brief Q&A session. So if you have any questions, please leave them in the Q&A box on the platform, and I'll get to them after this. Before I get into the subject under discussion, I think that it is necessary to address some concerns that have been raised about why a webinar on patriarchy and misogyny in any context is being headlined by a man. I have a few things to say about this. I agree wholeheartedly with the idea that women are best suited to address issues that vitally concern them. Women's voices should be heard and should be amplified. However, I think that for too long, the difficult problems that we have come to call women's issues have been addressed largely by women alone. There is in some circles this idea that women's issues are for women to care about and for women to talk about, and it's really not something that concerns men. And I reject that idea. I believe that anyone who is right-thinking, who is fair-minded, and who believes that we can make a better system and a better world should be a part of the conversation. And I think that it is time that men started actively talking about systemic problems that women have been talking about for years. Not because a man's voice will give women's issues any added legitimacy. We don't need that. But because the issues themselves deserve to be addressed through every conceivable avenue and by every possible advocate. That is why I'm here today speaking with a male ally. I hope and trust that this is only the first of many such conversations that will feature voices of women and of men and will also address issues of caste and class that sometimes remain unaddressed. Now, before I turn to Navroz with particular questions, I just want to contextualize the discussion that we'll be having today. In a recent order, a single judge of the Karnataka High Court considered a bail application made by a man accused of committing rape on a false promise to marry. While granting bail, the judge observed that the allegations made by the complainant were difficult to believe and that the complainant did not object to having a drink with the man and even let him stay with her until the morning. The judge added that the explanation offered by the complainant for this behavior, which is that she was tired and fell asleep, was, I quote, unbecoming of an Indian woman. That is not the way our women react when they are ravished. It is this part of the order that has rightly come in for a great amount of criticism. These observations have since been expunged, but what we are here to talk about today is why they were ever made in the first place and what that says about the system. Cases of sexual assault, including and especially rape, are historically underreported. The ones that are reported reveal some important statistics. According to numbers published by the National Crimes Record Bureau, 33,356 cases of rape were reported in India in 2018. Out of these, 31,320 were committed by someone known to the victim. So when you do the math, 94% of all rape cases that year were committed by someone the victim knew. And this is a pattern that has been noticed in years before as well. But a review of some decisions appears to suggest that acquaintance rape is not really seen as rape at all. And of course, marital rape remains an exception to the crime entirely. The adjudication of rape trials in general is consistent with rape myths and with patriarchal ideas about how Indian women view their own self-worth. This results in a prescriptive list of conditions that a victim must fulfill if her testimony is to be credible. Even in cases where the complaint results in a conviction, we find that the crime of rape is typified as one that robs a woman of her much valued chastity and honor, rather than one that violates her bodily integrity and autonomy. Even though compliance is often safer than resistance, judicial decision-making has virtually created a requirement of self-defense, which is unique to this crime. And this is despite the fact that India has, through legislation, abandoned the requirement of resistance and adopted the requirement of consent. The phrase habituated to sex is one that is also found often in judicial decisions, and prior sexual history tends to impact the complainant's credibility. In short, the system burdens the victim with the responsibility of fending off sexual assault. Rape is the only crime where a complainant's past behavior, her actions during the crime, and her reaction to it are all key factors in the result. Now, this is by no means an Indian problem. In her 1983 study on rape cases at the Old Bailey courts, Susanna Adler concluded that a believable rape victim would have to meet 4 tests. She would have to have been raped by a stranger. She would have to have resisted the assault and therefore suffered injuries. She would also have to be sexually inexperienced. And she should have had what society views as a respectable life. If 2 of these factors were present, the conviction rate was 33%. 3 factors increased it to 72%. The absence of any of these factors guaranteed an acquittal, and the presence of all factors would likely result in a conviction. I hazard to say that outside of a few notable exceptions, even in 2020, a similar analysis of Indian cases will likely yield a similar result. And that is what we're here to talk about today. Navroz, welcome, and thank you for speaking with me.
Thank you, Gulnar, and I'd like to thank LiveLaw as well for organizing this seminar on a subject that is close to my heart and which, in fact, I thought requires to be dealt with. It's a pleasure.
Right. So I'll get straight into it. There have been some important legislative changes over the last few years, most notably after the Delhi gang rape case of December 2012. Now, since 2003, prior sexual history has been rendered irrelevant by the repeal of Section 155(4) of the Evidence Act. And after 2013, the absence of physical resistance cannot be regarded as consent. But we still see judgments like Raja versus Karnataka in 2016, where the Supreme Court says that the victim's conduct was unlike a victim of forcible rape and betrays a submissive and consensual disposition. They also say that she was accustomed to sexual intercourse on the basis of a medical exam. We've also seen something somewhat similar in the Farooqi case in 2017, where the Delhi High Court said that in some instances, it may be difficult to say that there was a lack of consent when there is little or no resistance. And sometimes a feeble no may mean yes. Now, changes in statutory provisions appear not to have altered the way evidence is passed and appreciated in rape cases. What, according to you, are the most worrying value judgments and gendered notions that we see in cases like the latest one from the Karnataka High Court?
So, Gulnar, this is a good point. It's an important point, and I think it's a good place to start this discussion, and one may even call it a debate. So I really think that these value judgments and notions of gender, which probably are at the very heart of this entire problem, with a deeply patriarchal judicial system judging women who've been raped or sexually assaulted, can be broken down into 4 or 5 main areas, each of which, I'm sorry to say, is highly problematic. And I say this because each taken individually or in combination with 2 or more literally runs like a persistent thread through many of these judgments that I have read and been reading over the last 8 to 10 days. And this is true of judgments pre the amendments of 2003 and 2013, and regrettably post the amendments of 2003 and 2013. Now, these value judgments, which are so clearly ingeminated into cases of rape and sexual assault, are broadly as follows. 1, prior intimacy or familiarity with the accused is used by judges almost invariably to somehow disbelieve a victim and an accusation of rape, even in the face of overwhelming evidence. And this is all the more so if the victim has had prior consensual sexual relations with the accused. It's as if the judge with his notions of womanhood, can't even imagine that a family member, a friend, an acquaintance can commit rape. This patriarchal, male-oriented notion of a woman's right to sexual autonomy and to her body has vitiated many a judgment. You mentioned Raja, and it's a particularly egregious case. In Raja, despite the victim being kidnapped and raped, in fact, gang raped, the Supreme Court reversed the finding of the High Court, convicting the accused for rape. Not only did the Supreme Court completely disregard the legislative amendments post Nirbhaya, but made it a point of holding it against the victim that she was acquainted with the accused and didn't mention it. Similarly, in an equally egregious case coming up from the Punjab and Haryana High Court, namely Vikas Garg, the Punjab and Haryana High Court held it against the victim, a young student at Jindal, that those whom she accused not only of rape but of sexual blackmail were fellow students known to her with whom she had social relations. And the most egregious of all the cases that I have read, the same is to be found in the Delhi High Court judgment in the case of Farooqi. And last but not least, the order because of which I think we are all here today, the order in Rakesh versus Karnataka of Justice. So this is the first of the value judgments. The second is something which, at least to me, is astonishing. The consumption of alcohol by a woman is enough to lead judges time and again to discount an accusation of rape or sexual assault. It's as if a woman drinks, then she deserves what she gets, being raped. And you can almost hear the judge subliminally saying, who asked her to drink? Drinking is a male reserve. And if a woman strays into that male reserve, then she can't be blamed. She can't blame a man for rape. It's as if she loses the protection of the law. Equally, the alternate assumption, completely ill-founded, that if a woman has had alcohol with a man and then had sex with him, it has to be consensual. So you find this in Garg, Farooqi and Rakesh, to only mention a few judgments. Consumption of alcohol by the victim is held against him. And just look at the injustice. It's often linked to the first point. The judge not realizing that most people drink with friends and acquaintances. And here we begin to see, I'm sorry to say, the most troubling part of this larger picture. The victim, conveniently from the standpoint of the accused men, becomes the accused. And whether it's a defense lawyer or whether it's the judge, the victim is put on trial, not the men who raped her. And this is what discloses the patriarchy, the misogyny, and I would add, the hypocrisy of the whole system at its worst. Now, even more shockingly, this is to be found even at an appellate stage, at an interlocutory stage, even when a woman has somehow surmounted all the hurdles in the sessions court and got a conviction for rape. Vikas Garg is a case in point. In Vikas Garg, the judges showed their true colors. Using friendship and alcohol against the victim, they arrived at outrageous assumptions of consent to belittle the woman and almost disbelieve her case at an interlocutory stage. But of course, their hearts bled for the rapists. Young, bright men, they call them, with a great future in life, and therefore they should not rot in jail. So we have a lecture on reformative theory of justice and punishment, and the men are released. On the other side, totally insensitive language is used against the victim. The judge shows no understanding of what it is to be sexually blackmailed. No sympathy is shown to the woman who has been sexually assaulted, abused, and blackmailed. But, and I quote, "It is a travesty if young minds, of course male minds, are allowed to rot in jail." So that's the second value judgment. The third is an obsessive insistence that a charge of rape can be proved only if the woman has fought back, suffering injuries sufficient to establish absence of consent. Now, despite this being clearly counterproductive to the woman, fraught with danger to her body to the extent of endangering her life, and this is despite the proviso to Section 375 that was introduced by way of an amendment. And I quote it, "Provided that a woman who does not physically resist to the act of penetration shall not, by the reason only of that fact, be regarded as consenting to the sexual activity." Yet, whether it's the Supreme Court in Raja, the Delhi High Court in Farooqi, the Punjab and Haryana High Court in Garg, and the Karnataka High Court in Rakesh, it is held against each of the victims that she didn't resist. Here, possibly the most egregious judgment is that of the Supreme Court. And note the notions of womanhood intruding even in a short paragraph. I want to quote this paragraph. PW1's conduct during the alleged ordeal is also unlike a victim of forcible rape and betrays a somewhat submissive and consensual disposition. From the nature of the exchanges between her and the accused persons, as narrated by her, the same are not at all consistent with those of an unwilling, terrified, and anguished victim of forcible intercourse. If judged by the normal human conduct. And then you get this. She did not scream or cry for help. This is of utmost significance, as it is not alleged by her that the abductors had put her under fear on the point of any weapon threatening physical injury thereby. I think one could write an essay on the misogyny so evident from these few sentences. Now just consider. Alleged ordeal, the High Court had convicted the rapist abductors. Normal human conduct, according to whose lights? Men speaking as if 50% of the population doesn't exist. Because what do they know, given their antiquated, stereotyped notions of normal human conduct, which have intruded so clearly into this judgment? When it comes to a woman, let alone a woman who has been raped, or a woman who, as in the case before the Supreme Court, had been gang raped. And this feeds into the fourth common gender notion. The inordinate and irrational emphasis on a woman's chastity and virtue, honor, dishonor, and how this impacts her conduct both before, during, and after the rape and the sexual assault. This is also evident to make it worse, from derogatory, demeaning language and insensitive language used in judgment after judgment. And this is so common that it intrudes into judgments irrespective of the result. The most recent example of such obnoxious comments, of course, is that of Justice Dixit in Rakesh. But here I'd really like to take the audience for the first time and refer them to the Verma committee report. For in 2 short paragraphs, it calls out all that is wrong with the approach to rape and sexual assault. And I'm now quoting. An offense against a person is very different from an offense against a community. We think that there has been a completely erroneous connection which is being made between a woman and a community. In other words, we feel very strongly that an assault on a woman is an assault on the person of the woman. In this regard, we would like to quote Sohaila Abdullah, a rape victim, who recounts her experience which took place 32 years ago in Mumbai. Rape is horrible, but it is not horrible for all the reasons that have been drilled into the heads of Indian women. It is horrible because you are violated. You are scared someone else takes control of your body and hurts you in the most intimate way. It is not horrible because you lose your virtue. It is not horrible because your father and your brother are dishonored. I reject the notion that my virtue is located in my vagina, just as I reject the notion that men's brains are in their genitals. If we take honor out of the equation, rape will still be horrible, but it will be a personal, not a societal horror. We will be able to give to women who have been assaulted what they truly need. Not a load of rubbish about how they should feel guilty or ashamed, but empathy for going through a terrible trauma. And the Verma Committee report comment, we wish to take this point further. When a woman complains of rape, it is not the physical part of the woman which is directly the focus of attention. It is the offense and the offense against the bodily integrity of the woman as a person, which is the offense in question. We therefore think that we need a woman to be viewed as a whole and not as a physical center of sexual congress. At the same time, it must not be viewed that a woman, while making a complaint, is in any way acting less honorably or in any way disturbing what is considered as the repository of honor of the family, community, or society. Now, I said this intrudes even into good judgment. And there are 2 such, both delivered by Justice Pasayat, speaking for the bench, of course, in 2004. Regrettably, even though the judgment of Justice Pasayat in State versus Shrikant Shikari is an affirmation of the right of a rape victim, the language used discloses an outdated and outmoded mindset. Despite the Verma Committee report reiterating, subsequently of course, that rape has nothing to do with the community, the Supreme Court says the exact opposite. I quote, rape is not only a crime against a woman, it is a crime against the entire society. I'm sorry to say that, to me at least, it's almost as if the court is saying But for this, we wouldn't view the matter seriously. The court falls into the same error in the second judgment of Justice Pasayat, which is Punjab versus Ram Singh, by using similar language. I won't quote. I must, however, acknowledge at this stage itself that this judgment is otherwise a very good judgment, one of the few good judgments I've read. For it asserts two things which are both important. One, it asserts that previous sexual experience is irrelevant. To that extent, it follows the 2003 amendment deletion of subsection 4 of 155. Most importantly, it states that the only question for a court to consider is, did the accused commit rape on the victim on the occasion complained of? Nothing else is relevant, let alone of any importance. So I would say these are four of the most persistent value judgments that I found running through all these judgments.
So to take off from what you mentioned, Navroz, that even when the courts find that the accused is guilty, judgments are still premised on the notion of the ideal victim. So you're back to that old chestnut about, were there signs of physical and emotional trauma after the event, and sometimes even by leaving evidence. And women who demonstrate these signs are seen as being more credible than someone who did not fight back or had a more restrained response. And that's pretty amazing, because not every woman reacts to any circumstance the same way. And yet you have these boxes that must be checked if you are to be believed. And I think that it's particularly problematic when women are expected to physically resist and fight back, because often it means more grievous harm, possibly death. So my next question is really two questions. The first is, would it be an exaggeration to say that these prescriptive standards do not just undermine the judicial process, but seem to subvert it? And my second question, which is allied with the first, is that if it is subverted, then what does that mean for women's constitutional rights to full personhood and autonomy?
That's a good point. I've very briefly touched on it when dealing with the first issue. But to turn straight away to your first question, Gulnar, it takes us straight to the vexed issue. What do you do with judges who deliberately ignore statutory mandate, or worse, subvert it? The law on the subject, in some of the cases we've been discussing, exemplifies this. Nothing more starkly, according to me at least, than the manner in which judges brazenly disregard the deletion of subsection 4 of section 155 of the Evidence Act. Now, that subsection provided that in a prosecution for rape or an attempt to ravish, it may be shown that the prosecutrix is of a generally immoral character. To me, the fact that such a provision survived the 20th century is itself a disgrace. Finally, however, in 2003, Parliament was somehow persuaded to repeal this subsection. Yet, what do we find from judgments? We find disgraceful judgments of various high courts and Supreme Courts post-2003, constantly harping on a woman's previous sexual history and using outdated, derogatory language about a woman who's had consensual sexual intercourse with men. If that is not subverting the law to the immeasurable harm and prejudice of the victim, I don't know what is. But the same is equally true of the proviso to Section 375 pertaining to consent and not resisting, to which I have referred earlier. Now, as an aside, I've never read a judgment referring to an alleged rapist or even a convicted rapist as a man of easy virtue or loose morals or generally immoral character. So I asked myself, is this a coincidence? Is it pure oversight on the part of all these judges? Or is it a manifestation of a deep-rooted sense of male superiority in a society founded on patriarchy? And perhaps the most glaring example of this is the judgment in Farooqi. I want to deal with it briefly. Apart from liberally drawing on all these value judgments that we've just discussed, the judgment entirely perverts the salutary amendment to Section 375, way consent, as contained in that proviso. Now, what are the facts? The judgment records that the victim says no and gives a push to her rapist. While he's trying to remove her underwear, she is constantly trying to pull her underwear up to prevent being raped. Consent, you would think. Anyone familiar with what the Supreme Court in Rakesh called normal human conduct would say no. That can't be consent. But as if this isn't enough, the following facts are admitted. 1. There was forced oral sex. 2. The accused contemporaneously in an email to the victim admitted to forced oral sex and had apologized for the act without the victim's consent and against her will. 3. The judge comes to a finding that the prosecutrix met the high and exacting standard of what is called a sterling victim. A sterling witness, sorry. And 4, in his original defense at trial, the accused had not pleaded an alternative case of consent. Shockingly, contrary to precedent of the Supreme Court, all of which was, of course, conveniently distinguished by the judge, the High Court allowed this new plea to be taken. Now, with all this, one would have thought this is enough to uphold the conviction of the clearest case of rape. But think again. In a breathtaking feat of intellectual jugglery, the convicted rapist is found not to be a rapist. Now, how do we arrive at this conclusion? The first step in this construct is to say that though the prosecutrix, having said no, ultimately goes along, in her mind, she remembers the case of Nirbhaya and the fact that had she not resisted, she would not have been killed. But, says the judge, and now I quote, there is no communication regarding this fear in the mind of the prosecutrix to the appellant. The prosecutrix makes a mental move of feigning an orgasm so as to end the ordeal. What the appellant, that is the rapist, has been communicated is, even though wrongly and mistakenly, that the prosecutrix is okay, he puts it in inverted commas, with it and has participated in the act. The appellant had no opportunity to know that there was an element of fear in the mind of the prosecutrix forcing her to go along. Have we entered the world of Franz Kafka or Dostoevsky? And so this judgment goes on and on. till we reach the end, the ultimate insult and humiliation heaped on the victim, who by now, of course, has become the accused. So the judgment ends with these words. But it remains in doubt as to whether such an incident, as has been narrated by the prosecutrix, took place. And if at all it had taken place, it was without the consent or will of the prosecutor. And if it was without the consent of the prosecutrix, whether the appellant could discern or understand the same. So these are the sort of judgments that we've got. And while I've dwelt on Farooqi because it's the best example of a judge subverting the legislative changes, judgment after judgment does exactly the same. So that's the answer to the first of those questions. Now we come to the second. I want to touch on the issue of burden of proof before I actually come to the question of the constitutional aspect, which is unique to rape cases. And the reason I do this is because it's linked to something I've already adverted to. Because it is this which goes a long way to convert the accuser into the accused and is fertile ground for making the accused rapist the accuser. And I want to deal with this aspect of burden of proof and consent, not in my own words, but by referring to an excellent article published in 1993 in the University of Pennsylvania Law Review entitled Read Her Lips, an argument for a verbal consent standard in rape by Lanny and Remick. I'll just read the relevant paragraph. Of course, she's talking about America. In every state but one, the prosecution's failure to prove victim non-consent will result in an acquittal. The law thus creates what is in effect a legal presumption of female consent to sexual activity. Now, standing alone, such a presumption is inoffensive. It can be viewed as merely effectuating the constitutional guarantee of a presumption of innocence and reflecting the fact that the majority of sexual interaction is consensual. It is the combination of this presumption with judicial interpretation of the non-consent element that is problematic. Judges have historically held that the burden of proving non-consent is not satisfied by a lack of affirmative consent. Instead, affirmative non-consent must be proven. And then the author says, although there are other crimes for which non-consent is an element or consent is a defense, only in rape is proof of lack of consent insufficient to prove non-consent. A common defense to a charge of auto theft, for example, is that the car owner consented to the defendant's use of the vehicle. A mere showing that the owner never gave the defendant permission to take the car is enough to defeat the defense. No showing that the owner actually told the defendant not to take the car is necessary. In rape law, however, and this is very important, the default position is consent. Proof of the absence of affirmative indications of consent by the victim is not enough to defeat a consent defense. Instead, the prosecution must show that the alleged victim indicated to the defendant through her overt action and/or words that she did not wish to participate in sexual activity with him. And thus, the author now quotes somebody else, the law presumes that one will not give away that which is his to a robber, but makes no similar presumption as to the conduct of a woman and a rapist. Now, coming to the constitutional rights, I believe that the law as it stands, and more so as it is administered, makes serious inroads into a woman's constitutional rights, especially under Articles 14 and 21. Her right to the freedom to live her life as she chooses, where she works, how she dresses, what drink she consumes, who she has social and sexual relations with, are all impinged upon by this subversion of the judicial process and disregard of the legislative changes. And it is no coincidence that the Verma Committee report dealt with this in some detail in chapter 1 of their report. It asserts constitutionally guaranteed right of equality for women and says, quote, "We are therefore of the view that gender inequality is contrary to the unifying idea of a sovereign democratic republic." It further states, "This means that women are entitled not only to equality under Article 14, but are also entitled to the equal protection of the laws. Any offenses which are committed in relation to them should not be tried in a facially compliant manner, but in an effective manner, so that there is honesty of purpose, integrity of prosecution, as well as successful conviction of such offences, for which the state must evolve a dynamic review mechanism." And while Justice Verma, the parts I quoted, concentrate on 14 and equality, Justice Pasayat in Shikari and repeated in Ramdev has this to say, with specific reference to Article 21. "It is a crime against basic human rights, and it also violative of the victim's most cherished fundamental right, namely the right to life contained in Article 21 of the Constitution. The courts are therefore expected to deal with cases of sexual crime against women with utmost severity. Such cases need to be dealt with sternly and severely." And then comes a very perceptive observation from the Supreme Court. "A socially sensitized judge, in our opinion, is a better statutory armor in cases of crime against women than long clauses of penal provisions containing complex exceptions and provisos." And I would say, in a sense, Justice Pasayat has hit the nail on the head. The 2018 amendments increased jail terms for rape of a minor under 12, for rape of a minor under 16. They introduced new provisions. But I would submit that all this is of no avail if the mindset of judges does not change. So I think that effectively deals with the constitutional aspect. At least I hope I've dealt with it adequately.
Right. So we have already discussed briefly the legislative changes that make these particular circumstances irrelevant. So you no longer can introduce, at least under statute, it's no longer relevant what past sexual history there may be, or even of the woman herself separately from the person in question. And also, as you rightly say, the law was amended to say that a woman who does not physically resist shall not be regarded as consenting. But even so, this progress on the legislative front hasn't taken away these particular factors from being put into evidence. And even though they are statutorily obsolete, you still see them being put into defense. So, what do you have to say about defense lawyers who appear to undermine these important changes in the law in this fashion?
I know I need to tread on this a little carefully, but at the same time, I must be quite frank with my own views. My views are these. All lawyers, not only defense lawyers in rape cases, have both a professional duty and a moral duty to the court, to their own client, and to their opponent. As a practicing lawyer for 40 years, I have never accepted the cab rank rule. If it means that a lawyer is entitled to suspend his morality while fulfilling his professional duties. And this is true in all cases: civil, criminal, commercial, arbitration, family, taxation, all cases. I don't therefore want to suggest that rape cases stand on a different or a higher footing as regards the duty of a lawyer. But that said, I do believe, having now read the judgments, post these amendments of 2003 and 2013, that a defense lawyer in a rape case or a case of sexual assault owes a duty to the court, to his opponent, and even to his own client, not to subvert or circumvent legislation specifically enacted to further the cause of justice. Now, the subversion and circumvention by defense lawyers, as you yourself briefly adverted, of the deletion of subsection 4 of section 155 of the Evidence Act and the proviso to section 375 is particularly objectionable. And I say this because it is not objectionable only in itself, but because it is this which invariably turns the rape trial and those for sexual assault into a travesty and a perversion of justice. The victim becomes the accused. She is on trial. Alcohol, cigarettes, clothing, the places she goes to and frequents, the people she associates with, and those with whom she may have consensual sex are all brought into the picture. And I say that it is particularly improper because this reflects not only on the child and the rape victim. The effect of subverting or circumventing the law leads straight to an attack on the rule of law on which our society is founded. And therefore, I believe that whether it's a rape case, whether it's other cases, all lawyers, but to reply specifically to your question, defense lawyers in such cases owe a duty to the court, to the client, to their opponent. And I say to society at large, not just because they want to win a case and get their client off the hook, to deliberately and knowingly subvert or circumvent the law. So that's my answer.
Right. So the next question I have takes us slightly away from the law as it is today, because everything you mentioned does indicate why women don't often come forward at the first possible opportunity. They're often disbelieved, their life's choices are scrutinized, and as you've said twice over now, it's often the victim who is on trial. What can one do to create a system where women's complaints of harassment, of assault, are treated with the seriousness that they deserve? What do you think we can do to make that a reality?
Well,
More
that's a tough,
than it is today.
that's a tough one. But what I would say is this: having discussed the problems that we have, we know whom to address. The question is, and I think that is your question, how? So first and most important, I think, is to make the dramatis personae, the judges, the lawyers, the law enforcement agencies, government hospitals, doctors, as I'll point out when I refer to a judgment, realize and appreciate that there is a serious problem and that they are a part of the problem. And it's not for nothing that it is said that knowing the problem and accepting that it is a problem is half the battle won. So on this basis, on the basis that the dramatis personae at least accept that there is a problem and they are a part of it, I would say that educating and sensitizing judges and the others, such as the police, etc., is of the greatest importance and cannot be undervalued. And I'm going to exemplify this with an example from another branch of the law. I'm reminded in a different context of what Norma Alvarez said at an environment conference held by our Bombay Bar Association 30 years ago, at which the chief guests were Justices Kuldeep Singh and coincidentally Justice Verma. So she told the audience that she was arguing a matter to prevent the destruction of sand dunes in Goa. And she wanted to first tell the district judge what sand dunes are, how important they are, and why, therefore, one should try to prevent their destruction. And before she could even begin, and this is how she recounted it, the judge told her, yes, yes, I know all about sand dunes. As a young child, I also built sand castles on the beach. Now, Norma said, and everyone laughed, that instant, I knew I'd lost the case. And that whole conference has had some effect, as has this whole movement in the field of environment. And therefore, I say that sensitizing and educating judges in the area which we are discussing is the first and foremost thing that one should think of if the system is to improve. Secondly, the law enforcement agencies need to be educated and sensitized, and where necessary, pulled up and punished for disobeying the law. Now, let me give one example. In a judgment in 2000, in the case of Karnataka versus Manjana, the Supreme Court was hearing an appeal where the accused had been acquitted of raping a girl below 16. The Sessions Court had convicted the accused. The High Court, reversing that, had acquitted him. Now, when the matter came to the Supreme Court realized that there was a huge problem being faced by victims and their families. especially in far-flung rural areas. And this is how they dealt with it, and these are the directions they issued. And I'm quoting, "Before parting with the case, we wish to put on record our disapproval of the refusal of some government hospital doctors, particularly in rural areas where hospitals are few and far between, to conduct any medical examination of a rape victim unless the case of rape is referred to them by the police. Such a refusal to conduct the medical examination necessarily results in a delay in ultimate examination of the victim, by which time the evidence of the rape may have been washed away by the complainant herself or be otherwise lost. It is expected that the appellant state will ensure that such a situation does not recur in the future." Now you have a very good direction. My point is, has this been done? I don't know. Has anyone followed up to enforce the Supreme Court direction with the state? I don't know that as well. But these are things which need to be done. It's not enough to get a good judgment from the Supreme Court, laying down the law, or giving a direction, as in the case of Manjana. Civil society, others, women's organizations, undoubtedly. But civil society, people involved, must ensure that this is complied with. So that's the second. At another level, as a lawyer, I feel, if the courts, be it the High Court reversing the Sessions Court or a Supreme Court reversing the High Court, uniformly passes strictures, not only against the judgment, but I would say even against the judge concerned, then in the long run, it will have some effect. In all the three cases, the two of Justice Pasad and the one I just referred to, Manjana, while reversing shocking judgments of the High Court, letting off rapists, the Supreme Court, of course, in very mild language, passed strictures against the judgments. So that's the third. And the last is civil society itself. Not only women's organizations, not only women journalists, but society as a whole, men and women. If they protest, expose, and call out travesties of justice and subversion of the law in cases of sexual assault, harassment, rape, I do believe it will have some effect. The message must go out loud and clear, as it did to Justice Dixit, that such outrageous orders or judgments will be exposed to the public both nationally and internationally, and will receive not only criticism, but the severest condemnation. Now that, of course, leads me to the biggest problem. How do you change the mindset of men brought up from birth in a patriarchal, male-dominated world with biases, prejudices, and preconceived notions of women? Well, I'm going to cop out on this one, because according to me, that's a webinar in itself, and I at least will leave it there. But one thing is certain, after study of this subject for 10 days or more, there really aren't any easy solutions. But these are some of the areas, I think, which if we concentrate on, hopefully there can be some progress.
Right. Thank you for that, Navroz. And really, I'm now verging towards my last question. And that has to do with legislative change. As I see it, legislative changes in this area have come into being largely as reactionary measures. They've occurred in the wake of particular events or particular cases and seem somehow to be geared to deal with the problems highlighted in those events or cases. So, for instance, after the Mathura rape case of 1979, there was widespread condemnation of the Supreme Court's reasoning from women's organizations, from individuals like Upendra Bakshi, and that resulted in amendments to the criminal law in 1983. And we see the addition of the presumption of a lack of consent in certain prosecutions for rape, including custodial rape. After the Delhi gang rape case of 2012, there were also intense protests, and that resulted in the constitution of the Verma committee, which of course in turn culminated in the report and in additional legislative changes. Do you think that perhaps what we need now are more proactive legislative changes that are targeted towards mitigating this imbalance of credibility that women seem to face, and that are made after taking into account patriarchal double standards that women live with? For instance, in the definition of consent, I think that does leave the door open for lines to be blurred, and it becomes problematic not just for the complainant. It does become problematic for men as well. I mean, there are several instances where people say it was a miscommunication. As you know, there's a real problem of campus rape cases and so on in the States, and they've found ways of dealing with it, constituting committees at the university level and so on. So what do you have to say about that?
I think this is possibly one of the most important areas and possibly one of the most difficult. So I notice you've left it for the last. So how should I say? To answer this towards the end of our discussion, I need to go back to the beginning and to those value judgments and notions of gender of which we spoke. Because I think when you look at those carefully, they are all the direct result of one overarching notion, which in many ways explains and is the result of the others. And it's this: an Indian woman's life and her worth as a free, autonomous, independent human being is not considered of value in Indian society, and certainly not valued as much as a man. I don't need to mention anything beyond the prevalence of female feticide and female infanticide, which are rife in our society. And that itself speaks eloquently of the society in which a woman is born and has to live her life. So the way I look at it is this: if a girl is lucky enough to be born and survive being murdered by her family, she obviously starts at a disadvantage. From birth, her worth is devalued. She's constantly put down and debased. So analyzed and understood, this overarching notion is, according to me, if I may use a phrase, the root of all evil. Now, with this background, I turn to what can or should be done. Undoubtedly, I think the first thing is to amend the definition of consent. And I think, having now done quite a lot of reading on the subject, academic as well as case law, it must be express verbal consent and nothing else. An exception will undoubtedly have to be carved out for differently abled women. But with that one exception, it must be an affirmative verbal consent. And so in the definition, it's a small amendment. In the definition of consent, the words, gestures, and non-verbal communication must be deleted. The judgments, the perverse judgments in Farooqi, Rakesh, and Garg are eloquent testimony how clear non-consent by the victim has been twisted and perverted to signify consent. Secondly, and you've touched on it yourself, Gulnaz, in the proviso to section 375, those catch-all words, the escape route for all these judges, by the reason only of that fact, should also be deleted. We've seen that due to these words, judges have been able to get around express legislation. Rakesh is a case in point, as is Garg and Farooqi. Third, to effectively enforce the deletion of subsection 4 of section 155, the Act should be amended to mandate no discretion, that a judge must rule out as inadmissible any question of past sexual relations of the woman. Because, as some judgments have said, including the one I quoted of Justice Pasai, the only relevant question is, was the act of sexual intercourse in the case at hand consensual? Everything else is irrelevant. Justice Pasayat, of course, put it the other way. Is it rape? Everything else is irrelevant. Now you talk of proactive legislation. It's easier said than done. Proactive legislation is undoubtedly called for, but is often a pipe dream. Legislatures all over the world, this is not restricted to India, all over the world, almost universally legislate, especially on issues of gender, race, caste, etc., only when compelled to do so by some external force. We saw this after the Mathura judgment. We saw this after the rape and murder of Nirbhaya. Now, coming back to consent, and I'm also coming pretty close to the end of this webinar. A good definition that I came across amongst my reading is to be found in legislation in Canada. Just one second. Sorry. And that is dealt with in an article which I read, published in a journal called Missouri Gender Law Journal. And I'd like to just read out a passage from that article, because I think with suitable modifications, one could adopt it if we are looking out for a good, nothing is foolproof, but for a good definition of consent. So I'll just read out the relevant part of this. So this talks of affirmative consent in comparative law, and she's talking about Canada. One source of authority supporting the assertion that affirmative permission standard is unable to provide the basis for criminalizing many forms of sexual abuses of power is Canadian law. Canadian law has taken an important legislative step by fully adopting an affirmative consent standard. Under Canadian sexual assault law, non-consensual sex is the touchstone of the criminal offense. The basic premise of Canadian law is that the offense of rape is essentially an act of violence, an assault of a sexual nature. Consequently, the offense of sexual assault provides that a person commits an assault when, without the consent of another person, he applies force intentionally to that other person, directly or indirectly. The authoress carries on, while the definition of sexual assault incorporates the force element, the notion of force is broadly construed. By interpreting the force element to include any intentional touching, Canadian law, in fact, abandons the traditional English common law requirement of establishing severe physical force. Under the Canadian Criminal Code, any contact of a sexual nature suffices to meet this definition. The code further adopts a clear definition of consent for the purposes of sexual assault law. Consent is defined as, quote, the voluntary agreement of the complainant to engage in the sexual activity in question. But most importantly, and this would have obviated the judgment in Farooqi at least, the code states, the Canadian code states, no consent is obtained where the accused induces the complainant to engage in the activity by abusing a position of trust, power, of authority. And it also limits the defendant's ability to rely on mistaken belief in consent by stating, quote, it is not a defense that the accused believed that the complainant consented to the activity that forms the subject matter of the charge, where A, the accused's belief in consent arose from the accused's self-induced intoxication, or 2, reckless or willful blindness, or B, the accused did not take reasonable steps in the circumstances known to the accused at the time to ascertain that the complainant was consenting. I think this is a comprehensive code, and I do believe if one were minded with suitable modifications, maybe any amendment to the definition of consent in our legislation should draw upon, if not actually incorporate, this definition of consent. I now deal with one last aspect which you also mentioned right in the beginning, because I can't possibly end without reference to this, and that is the horrifying issue of marital rape. Now, the Verma committee report very strongly recommended deletion of this exception to rape as defined in section 375. It pointed out that this was rooted in antiquated times when a wife was considered as part of a man's property. It had no place in the 21st century. It also noted the prevalence of rape within the family structure and by relations, friends, and acquaintances. And you have in fact given the statistics. It suggested enactment of the following explanation. Quote, consent will not be presumed in the event of an existing marital relationship between the complainant and the accused. And I do think if we had to go anywhere in this area, this utterly obnoxious provision must be repealed. But of course, it was too much to expect from our legislation. And so today, in the third decade of the 21st century, wives in India will continue to suffer rape by their husbands without any recourse to them. Now, given the rather grim subject matter, you may be surprised that I may sound idealistic at the end. But I do think, and hope springs eternal, as the poet said, that if these suggested legislative changes, amongst others, I have not mentioned all of them, were to be effective, it would go some way in ensuring a more fair trial of a rape victim. where the victim remains the accuser, where the accused remains just that, where a woman's personal life choices are not on trial, but her rapist is, where a judge's scope to subvert the law and permit defense lawyers to undermine the trial process of the law is legislatively restricted, if not absolutely proscribed. And where finally, justice for all will not be a cruel joke for 50% of humanity. Thank you.
Navroz, thank you. We have a little bit of time left. Thank you for answering all my questions as fully as you did. There are a few other questions. We've had quite a bit of activity on our Q&A box. So there are about, since we only have a few minutes left, I'm not going to be able to pose all these questions. But so there are two questions that jumped out at me. One was, what do you have to say about testimony that is completely uncorroborated? Because, you then have only the word of the woman. And how does that tie in with rape cases that are false rape cases? Now, this is sort of the flip side of what we've been discussing. And I think that I would be remiss, given that there have been so many questions on this issue, I would be remiss if I wouldn't put it to you. So what do you have to say about...
So I'm glad you've raised it. First, the law and even some of the more obnoxious judgments grudgingly do mention this. Some don't. But it's almost universally accepted that in rape cases, you do not need corroboration. So that's the answer. There is no need for corroboration. The judgments say that. The Verma committee report extensively quotes judgments and says the same thing. So non-corroboration is no answer. False case. Well, the law is or ought to be adequately equipped to call out a false case from a true case. And merely because there will be, and I have no doubt there will be, some false cases implicating men, does not mean that you ingeminate yet one more thing, which at least our courts have set their face against, namely corroboration. So that's my answer.
Right. One last question. Now, this is actually related to the last question that I posed to you about legislative changes. And the question is, how does Mr. Sirvai see the Kerala High Court's recent judgment that construes consent as consensual only when it is welcomed? Because he says this might potentially negate the need for an amendment. I must confess that I'm not familiar with this Kerala High Court decision.
No, nor am I. And but I'm glad that my attention has been drawn to it, given that I've done nothing but read on this subject for the last 10 days, and 11th day won't hurt me. So I will read it if I have the citation. But I'm glad this issue of willing has been brought up vis-a-vis permission. Because the second article, it has a long title and I'm not able to find it in my papers. It talks of an alternate to the consent thing, and it talks of it as a power equation. Deals with this. And I made a note of it when I read it. She distinguishes between permission, which may not be genuinely willing free consent, but maybe because of this power equation. A woman who may lose her job, or relationships of teacher and student, priest and worshipper, lawyer and client, lawyer and junior, doctor, etc., as maybe consent in the sense of permission, but not willing free consent. And so she says that the template should not concentrate on consent as permission, but consent as the willingness of a woman to have sexual relations with the person concerned. So yes, I think if the Kerala judgment has said that, it's apparently a very good judgment. It's certainly forward-looking. It helps in dealing with, I won't say solving the problem. But ultimately, I think unless one has legislation bringing in all these concepts of willingness versus permission, you may have the odd judgment, but for every one judgment like Kerala, you'll have judgments like Farooqi, Garg, Rakesh, and others. So that's my answer.
Right. I think that's about it, because we're running out of time. Navroz, thank you so much for doing this, and it's been a pleasure.
Thank you. It's been a pleasure at my end as well.
Thank you.